Okay, first you can confirm that audible. Nice. Thank you for confirming, Alvin. So welcome to today's session on data protection awareness. As we wait for others to join, feel free to ask any question. Feel free to join us today. I want to welcome everyone to this session, the data protection awareness. My name is Eugene Okech. I'm joining from Capable. I'll be the facilitator for this event together with my colleague, Simon Mwachi. So in case of anything, please let us know so that we may be able to assist you accordingly. So we will give others, I can see people are joining, we can give them around 10 to 5 minutes. So at 12:08, we will be able to begin our session for today. Yeah, once again, welcome. And my name is Eugene Okech, joining from Capable Limited Company. Once again, ladies and gentlemen, invite you again to this session, the data protection awareness. Feel free to ask as many questions as possible. My name is Eugene Okech. I'm joining from Capable Limited, and I'll be the facilitator for today. Allow me to introduce our speaker for today, even as we wait for others to join. Our speaker for today is Cephas Okoth. Cephas is a data consultant, trainer, and as well as a privacy technologist with over 10 years of industry experience across cybersecurity, cloud, and GRC. He's able to assist and the organization to navigate strategic, operation, and technical privacy matters. So I beseech you all to ask as many questions as possible, because we have an industry expert who is able to answer all these questions even as we continue with the session today. Yeah, once again, feel welcome. My name is Eugene, and also my colleague is here. I'm watching to help us where necessary. So without saying so much, I'll welcome our expert, Cephas, to take us off for today. Cephas, you're welcome, and you can take over.
Okay, super. Can you hear me, Eugene?
Yes, crystal clear.
All right, good. First and foremost, forgive me in case you might have might not hear me very well. Just recently catch a flu, so I'm kind of nursing it. I hope that I can be as clear as possible and you can survive this. Thanks, Eugene, for the intro. I don't have 10 years of experience per se, but thanks for the thanks for the good wishes. So as mentioned, I work in data protection. Been doing cybersecurity before that, and because security and privacy are intertwined, I suppose that in any privacy conversation, there'll always be a security talk, and I hope that we can even compare the two as part of this presentation, and hopefully just appreciate the areas of convergence, particularly when you're looking at issues of threats and harms and risks across domains. Also, you'll allow me to go off video for this session. I think my internet will definitely slug at some point, just to prepare for that. Super. Great. So my assignment here is, I think, straightforward, just to take us through what I'll call the fundamentals, the foundational aspects of privacy. But then even beyond that, just appreciate how you can translate the fundamentals, whether it's principles, the ethical components, the legal requirements into practice. So we'll consider the practice elements of these issues, and hopefully go slightly beyond that as a bonus to think about some of the less common, less addressed issues, such as harms and privacy violations, and the threats and the threat environment around those. So. Good. So as mentioned, that is in a nutshell who I am. And I think I'd like just to emphasize on one thing around privacy technology. That's definitely an area I am keen on because of the extensive digital transformation that all of our organizations sort of going through, and how technology can be used to level up privacy practice, and at the same time also how privacy can be embedded within technologies. So all the technical aspects of privacy, starting with the privacy by design, engineering, etc., privacy in code. I think those are particular areas of interest. And in case you have any thoughts, you have any you're exploring these areas as well, or you need any advice, I can be able to hopefully guide you through it. So we're here to talk about data protection, but before protection, there's always data. And as commonly said, cliches that data is gold, data is oil, but out there, I say that data is worth more value than oil, worth more valuable than oil and gold. And straightforwardly, we all understand that data is important. Depending, doesn't matter which angle you're looking at it. Whether you are looking at it from a commercial perspective purely, or you're looking at it from a what should I call it, a non-commercial perspective. So it really doesn't matter. Data runs the world, aka oil. And so these are very straightforward, obvious importance of data, knowing that data has monetary value, it can be extracted, can be crunched, for real, and then be used to make decisions that can lead to monetary value. It can be used, and it is being used a lot for intelligence purposes, whether it's within our business intelligence operations, data analytics, science, etc., whether it's government and other public agencies putting out measures around surveillance, measures around spycraft and all that. All of this is all about data. It helps in terms of engaging stakeholders. And in this case, of course, if you're a business, you're talking customer. If you're a public entity, it could be citizenry or any other constituents that applies. Data helps you to understand your stakeholders, their pain points, their needs, and you're able to effectively engage those. And through all of this, you definitely can find an advantage strategically, tactically, whether it's from a competitive perspective or any other. Gives you an advantage internally, and that advantage can be extended into the marketplace. Even through innovation, right? You can use data to power your innovation practices. If it is revamping your business models, if it is, if it is doing whatever customizations you might need, based on your disruptive or non-disruptive business or product developments. So all of this could be very straightforward. Importance of data. And of course, when you talk of data, we are talking of data broadly, generally, whether it's commercial data, market data, industry data, personal data, etc. Depending on how you want to work the data set that you need. But specifically in this context, of course, we want to focus on personal data types. And that's where we now consider privacy. So let's talk about this privacy. What is privacy in a nutshell? Fundamentally, that is, there's a whole conversation around privacy fundamentalism. You guys can, do a quick research on that. But privacy essentially is just the idea that, each of us wants to be left alone. Each of us wants non-interference, whatever that looks like in your context. You want to be able to have your own space, have control over this space, and this space, of course, includes your data, personal data about you, right? So the fact that you want to have your own bubble and stay in it without being without your bubble being messed around with, unless you've allowed someone to or something to. Then that, in a nutshell, is the essence of privacy. Of course, we know, obviously, that privacy is necessary. And of course, we've also appreciated the importance of data. So, in the same breath, you can appreciate the importance of privacy as a way for you to keep what's your own, secure your own space, and have that control. And I think control is one of the words that we shall talk over and over again during this session. The fact that you're able to have control to what is privately yours, I think that's the bottom line, the necessity of privacy. Of course, this has to be contextualized, and there are many nuances to it. Benefits very straightforward. Downsides, Well, downsides can be arguable. I think much of the time benefits really overshadow the downsides. But I'll be eager if anyone has any thoughts around downside of privacy. If you can use the chat section. Someone says they're struggling to hear me. Sorry about ongeza volume. Okay, let me try. My vocals are not very well, but let me try. So, in case I was just asking, anyone has any thoughts around downsides of privacy? Use a context, use a scenario to explain how privacy can be a downside. Of course, by practice and within the law, there could be other aspects of exemptions based on certain specific needs. Question: these are those downsides to privacy, right? There be a point where privacy limits certain operations, privacy limits certain exercise of rights and freedoms. But of course, fundamentally, we do know that if I'm exercising my rights, the exercise of my rights should not infringe on your rights, right? Or your exercise of your rights. So these are also things to consider at a fundamental level. Principally, the essence of privacy, as I've mentioned, we just want to control what is privately ours, but then there's always the layer of ethics, there's always the layer of security, there's always the layer of law. So all of these things have to come in context when you're considering data protection. Of course, in line with the downsides, what do you think of what could possibly stand, in the way of privacy, stand against privacy? So think of a scenario that could negatively impact your privacy as an individual, as a group. What are the various things that could impact your privacy? And looking at it from the counter privacy perspective, you would then want to consider what by practice we call violations, right? So privacy violations, these are now the things that definitely breach your privacy boundaries, right? And in terms of privacy violations, there are definitely many things you can consider as privacy violations. But ask yourself this question, or let us ask ourselves this question: how can privacy be violated broadly as a concept, and then also specifically within the realms of the data protection? What are the various ways privacy could be violated? I was hoping this would be nice if this was a discussion, maybe in person, but I think because of the nature of the call, I'll just probably just highlight some of the various categories or ways that you look at privacy violations. As you can see in the, give me a sec. As you can see in this image on the left, that is, I think, your left or on my right, there are various issues or categories with which you can consider privacy violations in, right? So, for example, one category is invasions. Okay? Invasions under invasions, you can consider instances of intrusion, which I think is straightforward. Just straight up messing with someone's bubble, someone's privacy. Decisional inferences, where, of course, someone or a system can interfere with decision making. I think of these also within the realms of automated decision making, issues of AI and other automation models like robotics and all that. Of course, there are nuances to it. I have to keep saying that because privacy is then highly contextual and highly nuanced. Another category could be information collection. I think information collection, processing, dissemination in terms of transfer sharing, very common considerations in our laws and by practice. But again, you can find all these specific violation methods under each of these If it is collection, you could consider surveillance, interrogations, just as a ways for your own personal data, identifiable information, to be collected, and all of that. So you can appreciate. I don't want to go through all of them, but you can appreciate these categories, and hopefully within our own privacy practice, or when you're considering potential when you're considering impact assessments, when you're considering risks assessments and all that, you can need to consider what constitutes privacy violation. Under privacy violations, some things could be straight up legal, legal backed. Some things could be more ethical, right? You could find cases where privacy violation has happened, but there's no ultimate harm there. The data subject involved, right? How do we sort of draw the line when we are considering some of the impacts of privacy? So again, you can take a snapshot and use this list as a working reference, just to sort of frame your own understanding of violations. Of course, this is again this is very broad, right? This is just privacy as a concept level, but I think you need to appreciate this within the legal and the practice frameworks that each of us uses on a daily. And because we are talking about data protection, fundamentally, why is this important? Straightforwardly, yes, there's privacy as a right. There's privacy as a right. There's privacy as an ethical issue. There's privacy as a fundamental need, human need, I guess. But then in terms of data protection, we see a convergence of multiple things, typically privacy, security, ethics, of course, issues of trust and safety also come in play as a broad concept. So you can definitely consider these combinations of things and look at data protection in that way. I think one of the key goals of data protection that is very commonly spoke about is enabling trust, right? Whether it's digital or otherwise. I think trust is a key currency here. And so everything else can lead to trust and safety, because that is fundamentally what you're trying to achieve here. So data protection helps us to commit to some ethical or legal standards. I think that's why we have all these laws and regulations and all that. When I was studying undergraduate, my professor back in the day used to tell us that, hey, law floats in a sea of ethics. Law floats in a sea of ethics, which essentially means that laws are great, but fundamentally ethics is the bigger picture, or rather ethics informs a lot of the legal provisions that we have. Because again, it can boil down to just doing the right thing, right? Laws just help us, gives us boundaries of what is right and what is wrong. And I think this could also be informed by our own, I think psychologists call it, wow, I've forgotten the word, but the idea of understanding what is right and wrong, right? So all of these things could, this data protection from working, just helps us to commit to what is right, what is ethical, for our own selves, and of course for our stakeholders. And in that big picture, we can be able to limit risks, limit harms, enhance our security, and at the same time improve our own operations, whether it's a product level, data level, our own operations within the organized processes. Within the organizations, and all of that good stuff. Of course, largely because you're talking about law and regulations, accountability is key. And I think in the next slide, we'd appreciate, maybe 2 slides down, we'll appreciate one of the key reasons why all these laws and regulations are in play. Is for one of the key things is for accountability. the public bodies need to hold other organizations accountable, and other organizations themselves can use the laws and regulations as a framework to demonstrate their accountability, aka compliance, right? So how does so we'll consider data protection in broad perspectives. Look at it from a risk-based perspective and also accountability-based. Much of the time, both of these go together, but it's important to sort of distinguish the two. Where risk-based is the good old typical, hey, what could go wrong? What can we do about it? How does that look like, right? We are talking about risks. At the end of the day, as a business, as an organization, we're just trying to manage our risks so that we enhance all the other positive aspects, all the other operations of our own ecosystems. And then, of course, as I'd mentioned, because we have all these frameworks that we need to abide with, whether voluntary or otherwise, then gives us a way to be able to, it gives us a roadmap. This framework gives us a roadmap towards a reasonable, sensible data protection posture. And in doing so, we can be able to account even internally or to the regulators with regards to the best practices and just doing what is right as per the regulations and laws and all that. And in doing that, of course, we can be able to demonstrate compliance. So yeah, you can think about those perspectives. But of course, all of this comes with costs in case there are any non-compliances or any breaches. Clearly, you can see some of the 5 cost aspects. In case data protection is not up to par, and that is determined as so. I think the costs are pretty much very straightforward. With regards to non-compliance. So I did mention earlier that accountability is a key purpose of why we have laws and regulations. You can appreciate the others as well. Harmonization. The laws gives us a harmonized way of looking at data protection broadly. Provides for us that must have bottom line, that must have flow. In terms of compliance, we normally say compliance should be the flow. As much as possible, go beyond compliance and just do what is best, what is right. And of course, transparency. Laws and regulation force transparency, which is great. We all would appreciate some of the issues we've had, quote unquote, the big tech, how we do a lot of things behind the scenes, submarine strategy that we can never know about, right? And things that impact our own privacy, our own security, our own identity. And I think we've had reports where biases, extraction of data and users of that data for monetary purposes without these firms being able to be transparent. But again, the law helps us just to at least put some focus on organizations, including you, as I suppose, for you to be able to inform, be open about your data practices, etc. Also, I mentioned trust and safety, which is critical. The consumer citizen level. Since you're in Kenya, of course, we need to appreciate the Kenya Data Protection Act. The history is very straightforward. Since 2019, I think we've come along talking about the deeds in terms of principles and different segments of it. But again, we'll just go over a few of them, which I think are suitable and important, those who might need it. Purpose of the Act, I think building on, of course, the harmonization, transparency, accountability. Keenly, this Act is just meant to emphasize, bring to effect the Article 31 of the Constitution, which talks about your fundamental right to privacy, which can either be offline or online, digital or physical. So again, just comes into sort of reinforces that within the digital realm mostly. And then, of course, we have now the Office of the Commissioner that regulates, that provides guidances in terms of regulation around data protection, ensuring that rights are enforced. And then, of course, the Act as well just provide general requirements, obligations for organizations that fall under the jurisdiction of the Act, which I think is pretty much all of us. Because there are other, you can look at the Act directly, the text of the Act, you can see a lot of different high-level purposes for the same. Personal data, first thing we of course we need to know is, what does personal data mean? And in this case, let's look at the types. These are the broad overall personal data types. Based on the categories, I think I have another. Yeah, let's look at this second one a bit more detailed. So you can see we have things that are more typical: personal, your email, your name, your IP address, etc., and things that we probably interact with on a daily basis, right? We share on a daily basis as direct identifiers of our own uniqueness. We have some sensitive categories of data. This is what typically you hear people say, special categories of data, right? Because of that high sensitivity that they have. As you can see, there are some of the more the things that we don't like talking about a lot. Get into organization, they tell you we don't need your political opinion. Get into some group, they tell you we don't care about your religion, all that stuff, race and all that. So clearly, based on the data set you have, you can clearly categorize data as sensitive, as behavioral, because of the things that you do on a daily basis, our inclinations, our preferences, our historical data about our activities, particularly in the digital realm, that can be used to create a behavioral profile about you. And of course, that's what a lot of successful tech companies do. And then we now have the general societal information that is out there. Right? So these are the general categories of data. You can then use these categories to apply to the data set you have. In terms of collection of these data sets, these data types, this is an excerpt from the KDPA. You can see page 19 here. So this is just a breakdown of what does it mean in terms of collection. First, of course, typically data should be collected from a data subject, an individual directly. I think that is very common, but then in some cases, data can be collected indirectly. And you see there's a list of A to F in terms of scenarios there, where the data is collected, where the data is, can be found in a public record. Data subjects has deliberately made the data public. Think of the case we now have with our MPs and the police officers and all of that. What if they'd made the information public, right? At some point, you can easily pick that and as a data that you can then share, because anyway, the data has been deliberately made public as a public officer. And all these other scenarios, of course. One I'd like to highlight is in terms of when you're collecting data from a third party about an individual, that data the collection has to typically be consented to. It could be that the third party has obtained consent from that particular data set, so that consent is attached to that data and can clearly be demonstrated so before sharing. And of course, part of the consent is that the data subject consented that data to be shared as well. So you can consider these different scenarios and apply them to your various contexts. Again, the beauty about this section is that it's very straightforward, in my own opinion. You can clearly identify which particular reason applies to your situation. Let's appreciate the principles. I think I've mentioned this a couple of times. Fundamentally, whether there is the law or not, some of these privacy principles suffice. But of course, if you're talking of the law, then you have to consider issues of lawfulness, which is lawfulness, fairness, and transparency. Lawfulness being straightforward, that hey, we need to abide by the law. Everything we need to do has to be legal, so to speak. Fairness is a bit of a fluid issue. Question is what is fair, what is not, and be very contextual and has to be demonstrated. Justification and rationale has to make sense. But I think there are frameworks around fairness out there that can be applied if needed. Of course, based on the context, the transparency which you mentioned earlier is just about, hey, informing people, being as open as possible to your constituents around your data processing practices. You need to practice purpose limitation. So here you limit the purpose, you limit use of data for this very specific purpose that you collected it for, right? If I've collected data for as a HR office, you've collected data for recruitment because you want to interview some people, go through the process of recruitment with them. That data has to be specifically used for that purpose and potentially even obtain consent for it for that specific purpose. In case purpose changes, then we need to obtain a new consent for that particular purpose. Of course, there's a secondary use of data, which quote unquote is illicit, because any specific purpose has to be told to the user or the data subject. Then there's very specific legal basis applied to that. We need to minimize the data that we collect, process, how we process this data, how we store this data, etc. So the principle of data minimization just essentially says that throughout the data life cycle, let's practice as much minimization as possible. At collection level, only collect the least amount that you need for purpose, with the relevant legal basis applied. At processing level, let's only process the least, let's practice the least amount of processing that we need at each particular point in time, right? And that applies across all the other aspects, whether it's storage, whether it's transfer, sharing, and all that, right? Clearly, we all need accurate data. So accuracy as a principle should be very straightforward. You should be able to update, rectify incorrect information, as good practice. We can limit storage. Storage limitation here essentially means that, hey, we have these data sets, but we need to set a boundary as to how long we are going to store this particular data based on our needs and maybe other statutory requirements. So we need to limit the amount of time we're storing the data. So store it for the least amount possible, or if you're done with it, done with a particular data set within a particular process, you'd rather delete or dispose that data in whatever form. Alternatively, you could practice abstraction methods or enhancing methods, just to ensure that that data is not particularly directly active. But I think we shall discuss that in a bit. Integrity, confidentiality, those are security objectives. As I did mention earlier, security and privacy are two sides of the same coin. So we shall appreciate integrity, confidentiality a bit, a couple of slides down, as security objectives and how that fits into the privacy objectives. And lastly, as I've mentioned, legal framework, regulatory frameworks enables accountability. We need to be accountable to someone, to something like a framework, and the law helps us to do that by demonstrating, assuring this accountability, demonstrating compliance, and all that is related. So these are fundamental principles around data protection, and of course, the legal basis as to the sort of support processing based on these principles. These are the typical six legal bases, or you can call legitimate. And there's a way they create well, I think the word has disappeared. But essentially, this provides you a legal ground or a lawful basis for whatever type of processing you need. I'd just like to make a few disclaimers. One, we typically use consent. I think consent is as a basis is very common, probably the most used in an affirmative way. But I normally say that consent should not be your number one go-to legal basis. So you should think of consent as your last resort. Let consent be your last resort, because the challenge in consent is that it can be given and withdrawn. And once withdrawal has been done, what happens, to the processing, right? But it makes more sense to rely on the other legal basis first before consent. Legitimate interest is a very common one as well. Typically, it is used in scenarios where processing of data is needed for core business activities, right? But of course, even in legitimate interest, you have to understand whether it's necessary. So there's a whole necessity testing to it. Balanced, it has to be a balanced use or balanced processing, where you need to balance off the interest of the business with the rights and the interests of the data subjects involved. This is important because we do want organizations to use legitimate interest, because there's no active consent that is needed there, to do all manner of processing based on their commercial interests, that this processing could then impact on the rights and freedoms of the individual. The individual might not have any power or control over how that processing is done. So legitimate interest has to be assessed before you use it. So there's something we call legitimate interest assessment, LIA, that can then justify whether legitimate interest is a viable basis. There's a case recently where Facebook, this is in the EU, where Facebook sent notifications to users in the EU and telling them, and sent an email to users in the EU telling them that, hey, from this date onwards, we are going to use all of your data in Facebook, Instagram, for AI purposes. So that is, of course, the training and testing and all that. And they cited legitimate interest as the legal basis for them to do that. Of course, users share their concern. Regulators in the EU share their concerns. And at the moment, Facebook has stopped, has rescinded that decision to use people's data in their AI activities, based off of this particular basis. So it's a developing story. It's one to watch. You guys can Google and check that out. Public interest, of course, we all know the government is probably the biggest consumer of our own personal information. Right from the time you're born, government has your personal data, your name, your mother's name, your social networks, including your parents, your brothers, etc. So, government has to use data for public interest good. So, that could be a reason for them to do that. There's an element where, contractual needs abound. And so if you get into a contract with a company A requires you to provide them with certain data, and you do that, then they can claim that their processing is needed in order to perform a contract. But I think that's also one common one. Legal obligations, there are scenarios where certain legal actions or activities have to be performed, and because they're legal and they have to be done, then processing is obliged, right? No questions about it. Let's say in a case of a criminal case, it's a case in court, very straightforward. The court needs your information. The court has the power to even ask for your information. And vital interest as the last one, in case you guys know vital signs. It's a medical term that is used by the medics to categorize certain aspects of your medical history. So typically, if you walk into an hospital, the first things they would want to test is your vital signs. Your blood pressure, probably your weight, BMS, I think, and blood tests and all that. Very basic, vital factors of your health. It's the same idea here, where they're saying that some processing is just too vital because it's either a matter of life and death, and so some processing has to be done to save a life, or has to be done to prevent some certain harms, fundamentally to be done. But of course, based on your context, scenario, and situation, use case, you need to consider which basis applies. General obligations of all of us as organizations, whether you're a processor, controller, and for those who might not have, I don't know what controller, processor mean. So that a controller is essentially any organization entity that determines why data is being collected and processed, and how the data is being collected and processed. So what you typically call the why and the means of collection and processing, and then data processors, and now the second, third-party actors to whom controllers share data with for specific processing activities, right? In this case, for example, your bank is your data controller, and your bank shares data with some analytics companies that crunch that data for them, give them reports and insights for them to make high-value decisions. Those analytics companies are processors in this scenario. The obligations, these are very high level, and I borrowed this from the GDPR. It's pretty much the same with the KDPA. As I mentioned, you can see this is also a differentiation. You can appreciate the difference between the two. But generally, the requirements and the obligations in terms of practice for both are the same. Of course, with some standards for each, some specific components which have some standards, for example, in terms of breach reporting, and the escalation of the same, which you might check in the Act as to what is the role of each party. But yeah, I think I'll share this slide deck and you guys can appreciate that in the interest of, can read this in the interest of time. Critical one is data subjects' rights. As I did mention initially, privacy is a right. It's a rights issue. But at the same time, the idea of being left alone, coupled with the idea of having control, leads us to data subjects' rights, right? So rights here basically mean, actually the whole premise of data protection is built the idea that users, customers, or whoever is the data owner, that person who shares their personal data must have control over collection and processing of their data. So that's the whole premise of data protection, and rights help to effect that premise. Including one, you have a right to be informed. You need to be informed what data is being collected about you, how it's going to be used, handled throughout all the processes that are going to action on that data. Two, you have a right to access the data set that is being held about you by an entity. So that entity is obliged by the law to consolidate all of the personal information they have and share with you in a format that is electronically accessible to you. You can be able to review that. You have a right to rectify any data that is incorrect, inadequate, or any updating that you need to your data. So you can exercise the right of or correction. Then number 4, right to erasure. This is typically the right to be forgotten, where you can ask an entity to delete all of their data, all of the data they have about you, for whatever reason. But of course, this right to be forgotten has the condition that, of course, if all of your data is disposed, that essentially you cease to be a a beneficiary of the services that that entity provides, right? Because they can't serve you without all this data. But of course, also a company will not just blindly delete. There are other considerations, whether you have pending business with them, whether you there's some transactions that needs to be done before the actual deletion, before they actually move yours, from their data stores and all that. So yeah, there could be conditions for that. You can exercise your right to restrict processing. Certain processing that might be being done. You can request that certain aspects of that processing not be applied to your own individual data, while the other sets of processing can happen. But of course, again, it just depends on your need and the context. You can request your data to be shared. This can be linked to right of access. So portability essentially means that you request your data, access to your data. That data can be shared with you, and you can share that data in a specified format, even with other entities, right? It could be Bank A, you get data from Bank A, you share it with Bank B using the existing format that has been shared with you. It could be a case where you request Bank A to share information with Bank B in a certain specific format. Again, that's just portability. Data should be able to move. You can object to certain processing, including, let's say, marketing activities. That is a notorious one. You can object to certain marketing activities and all that. But of course, there are other scenarios where you can clearly just object to processing justification. And then lastly, we all know automated decision making. You can straight up think of it in the context of AI. And then profiling for whatever targeting, it's advertising or marketing and all that. So you can then object to this automated decision making, especially in the case where final decisions are made only through automated processes without regard for human interventions or human considerations. You might request for a manual review by a real person of certain decisions that have been made out of an automated process, because it is human who will understand your own biases, your own situations, your own challenges and limitations that a machine or an automated system and algorithm might not really get it. So these are your general rights. Of course, there are nuances, keep mentioning these nuances, contexts, caveats to a bunch of this based on the scenarios that you might find yourself in. I did mention consent as typically a last resort and not the first. Of course, consent is not a silver bullet. We use it a lot. Sometimes I see it misplaced, to be honest. But it's just one of the legal bases. There are the others which I think should be considered first and foremost. But in terms of consent, first you need to know that the data subject has the capacity to understand and communicate, to understand that which you're informing them about. Remember, you have a right to be informed. So if you're given a content notice or a certain notice statement for you to be able to read, so that you understand processing that is going to be involved in your data, you should have the capacity to do that. Otherwise, if you're incapacitated, that is essentially null and void, right? If you're mentally incapacitated or you're incapacitated in whatever way, that means you cannot fully exercise consent. Of course, I've mentioned data subject should be informed of all the processing all the factors around their processing in a way that is clear, very simple, very straightforward for them to get it. And lastly, of course, consent has to be specifically affirmative and informed. So in terms of consent regimes, there are multiple, but common ones is always opt-in and opt-out consent. So in opt-in is where you are given a mechanism for you to, by the action of doing something, you confirm that you've consented. It could be ticking a box, pending your signature and all that. That is an opt-in consent. You're opting into certain processing. But at the same time, you should be given a mechanism for you to opt out or withdraw that consent. So as easy as it is to opt in, it should be as easy as it is to opt out. So that's the opt-in regime. There's the opt-out regime, where, and this is typically in the US, where by virtue of you signing up to a service, it's been, what's the word? Let me use the word assume, because the other word has disappeared. It is assumed that you've given your consent by the fact that you've opted into you signed into a particular service. But then in this scenario, with this inferred consent, then you must be given a mechanism for you to opt out. So the only mechanism you have is opt out. You know, whether it's signing or clicking on a certain link and then saying, "Hey, I unsubscribe," and things like that. Those are opt out mechanisms. Those are the two consent regimes that are very common. But I think there are others you guys can sort of just Google and find that out. But fundamentally, you should consider all these must nots of consent, if consent has to be valid and make sense. And then maybe as a last aspect of the law, penalties are critical, and there are typically four areas that will cost in terms of penalties. Administrative are very common, much of the ones we've seen out here. Criminal offenses, there's a case of a Safaricom and the Safaricom agent disclosing data of subjects, and it became a case. And then Safaricom was not criminally implicated, but the agent was. I think that's a case you guys might want to look into. I think be an element of a criminal offense involved there, but it's just good to know. Criminal offense could be at the organization, of course, the individual level as well. Each individual can find themselves in a criminal case because of poor data protection actions. General penalties, in a case, for example, where you've not registered as a controller processor, right? Processing without lawful purpose, and these are things that, if an audit is done or an assessment is done, can be found out, and it's slapped with a general penalty because of not fulfilling certain principles. And then, of course, compensation is not essentially a penalty, but as an entity, of course, you can be civilly sued, can be put in a civil suit, and you might be made to make compensations for the harms made to individuals. And that brings me to organizational privacy, where we now consider the law, the regulations, and all that, and how it can fit into an organizational model. And first thing I'd like us to understand is program and strategy. I think that's where we need to begin at a high level. That hey, we want to do data protection as an organization, but then we need to now start thinking, what does our strategy look like? And maybe build a strategy that is aligned to the overall business strategy. Define your visions, your missions, what values, privacy values do you want to live by as a business, etc., etc., and then try and craft a program around it. I know typically we do data protection without a formal program in place. I've seen that a couple of times, but being able to devise a formal program can really help in terms of top-down approach, and ensuring that all the different components are put in place. And that then goes down to management. And for management, you'd want to probably adopt a framework that can help you sort of organize and coordinate all of the privacy activities. And when it comes now to the program working, governance is definitely, which can of course fall at the program and strategy level, is something you must start with, because you need the management board to have buy-in and support, and that agency for them to to set aside resources and monies and that is needed for privacy work, including policies and procedures, right? So we need to have those documentation, whether it's doing a privacy charter, setting up a privacy committee or an audit committee, and with the relevant charters and all that. I think at a high level, governance level needs to be catered for. Then now to the weeds of actual privacy program management. where it's a mix of project management, all the aspects of planning, execution, and I think that multiple models you could really look at: planning, actioning, monitoring, evaluation, and all of that, including reviews and assessments. And all of this could be a management function, which then aligns to the operational functions, where we do a lot of the things we've spoken about, where we practice the actual requirements of the law, whether it's rights management, vendor management, breach management, and all that stuff. So you can use this as an organization, as organization framework, or a framework with which you organize your privacy program. But whatever really works to you, having a privacy information management system um, um, as a framework, and then also if you can adopt a tech to help you implement, especially the privacy operational work, the better for you. Of course, don't forget about your website. That is your one public-facing asset, and there's a whole aspect to website privacy and doing audits for website privacy and all of that, which I think I cannot discuss now. In terms of operations, as I mentioned, it's just about translating what is in regulations and laws and best practices into actual day-to-day activities. And privacy operation at the moment is the framework that we use just for implementation and operationalization of all the different aspects in any framework, really, whether it's the law or industry frameworks. Operations is where the rubber meets the road, is where the actual practice happens. And the demands of the law are translated into daily business activities, which involves all of these teams, whether it's IT, product, security, engineering teams, etc., with the relevant continuous monitoring and improvement throughout the process. You can see the cycle on the left gives a sort of a high level view. There are other components that are not here, but it's just to appreciate how privacy ops sort of is the center of the different day-to-day management, day-to-day privacy work done in an organization. This is a tabular view of the same. As I mentioned earlier, we'd want to appreciate or link principles, obligation, requirements in the law to typical privacy functions. And this is just a snapshot of it. When you're talking about consent, then we need to focus on consent management, data rights management, policy, which is policies and procedures. Then you can build a whole policy framework of policy management system around it, etc., etc. So again, this is just a tabular view, simple tabular view of the same. And lastly, as I mentioned, you can adopt a privacy technology to support your privacy operations. There are different tools out there and all that. Won't discuss that, but it just helps you to have that integrated, automated or semi-automated orchestration of your privacy work. Again, the importance of this is that it levels up efficiency and helps you deliver faster, quicker, more accurately, have that level of intelligence in terms of how your data actions happen and all of that. We can discuss this behind the tent if anyone is interested in privacy technologies, adoption, deployment, and even just assessing necessity and readiness of privacy technology. We can always discuss this outside this forum. This is just an organizing reference. What is interesting, where you now have governance and all the governance aspects, operations, where I say where the rubber meets the road, would merge operations and management. But again, the idea is just to have the governance, the operation level, and then of course down here we also have the tech level or systems level that sort of run the core services of the business. As I wrap these up, I'd like to now appreciate privacy and security, and particularly the objectives. So we typically know security is what we typically know. We want to be able to consider risks, security risks, the organizational and systems level. And the core objectives are normally the CIA. You could add accountability there as a component, but that notwithstanding, CIA is always the straightforward objectives. In terms of privacy, a bit different. So in privacy, of course, privacy threats are introduced by a system. So it could even be a person, right? Even be a person. Person could be a threat, right? So could abuse. Now, these threats typically, unlike in security, where we typically talk about systems. Of course, there's the entire data that runs or lives in these systems, but we typically talk about systems. Here, we are really talking about the constituents, the data subjects, the customers, whose data are being held or processed by the organization, and all of their social networks. Remember, if privacy is not just me, it could be that the family is involved, like close associates are involved, right? Within a privacy breach, right? So the difference will be that in privacy, we really are talking about the end users, the ultimate persons to whom harms will be done, right? And as you can see, we have both a combination of the CIA here, and then we also have the extra principles or objectives, which is unlinkability, transparency, intervenability. Transparency is, again, what I mentioned before, just being open, forming as much as possible. Unlinkability is where we now consider how data, personal data, is linked to one individual's identity, right? I remember when you talk of things like anonymization and pseudonymizations, those are techniques for to enable unlinkability in a sense. But I guess that's also the scope of today's session. Intervenability, back to what I had mentioned earlier, the basic tenet of data protection is user control. So an intervenability is really just about enabling data subjects or data owners have control over processing of their data. And in doing so, they can be able to intervene by performing certain actions, changing certain settings, like, for example, changing settings. You find some services that come with some privacy default settings. A user should be able to be given an opportunity to change that default setting or whatever actions. So a user at some point should be able to intervene in terms of their privacy setup and make changes as it needs. So that element of user privacy control is important. So those are the extra principles for privacy. Again, not very well mentioned, at least in the ecosystem, but I thought it would be important to appreciate these when you're considering privacy, especially from a practice and system perspective. Of course, when you talk of privacy threats, as I've mentioned, because you're talking about users and their social networks, and in this case is always who is the ultimate who's the ultimate person to whom harm will actually happen, right? Could be that my privacy has been breached, but the person who actually experiences the harm is someone else, right? So privacy harm, again, I give you here an image on the left with which you can just think through privacy harms or frame privacy harms. And it could range from just normal physical harm, someone being beat up, someone being murdered, etc., someone being sexually abused, economic harm, very straightforward. You could lose your economic value, you could lose money, you could lose an opportunity, right? Your reputation, very straightforward. Your reputation can be harmed because of maybe data exposure, data disclosure, right? And things like that. Then you have a whole set of autonomy harms. I think the word autonomy is very straightforward, just about you being able to be free to exercise what you want, So if autonomy is reduced, then you can have all these different sort of, examples of harm that impacts on autonomy. Coercion, I think, is one very straightforward one. Lack of control, again, very straightforward one. Not being able to have control over your data and its processing and all that. So again, just use this as a model for you to consider harms. So essentially, what this means is typically we have a privacy threat. A threat actions on a certain weakness, what we call a vulnerability. And then from that vulnerability comes risks. That's how we get risk, right? And then you can always evaluate what risks and the impact or the severity of those risks. But then even beyond the risks, and their actual harms to actual people, right? The risk could be the risk could be the risk could be data disclosure, but the ultimate harm is reputational harm, right? Is reputational damage. So you kind of need to separate what risk is, what the harm is, in terms of the actual damage that actually happens, actual real life. Right? So again, this is just a framework for those who are interested in privacy threat modeling. This could be a way to think about, to sort of tie in what threats all the way to risks, to harms, and all that. And these are real things that happen. Hopefully, you can have more and more conversations around this. And for me, that's a wrap. Hope my goal was to cover these 4 areas. I hope I've done that, taken over. But I hope all of these help. Eugene? Eugene, can you hear me? Can anyone hear me? Seems like we've lost our hosts. Okay. Any questions? Any comments? Feel free to use the Q&A or the chat section. Any questions? Any comments? Any thoughts? I can now do my video just briefly. Video record. I don't know if this. I don't know if this session was being recorded, but maybe Eugene can advise. On that. Let me see. Sorry for those whom I could have struggled to hear me at some point. As I did mention at the start, having a cold. Finally, nimefikiwa na hii baridi ya Nairobi, homa ya Nairobi, but I hope that we've at least gotten the gist of presentation. So again, if you have any maybe thoughts or comments, feel free to drop them in the chat, the Q&A section. Let me also just drop my contacts information here. So as Nairobians say, we can tunaweza ongea nyuma ya tent. Be glad to have further conversations. Contact information. And connect on LinkedIn as well, for those who are there. Okay. So yeah, I've just shared my emails and my LinkedIn on the chat. Feel free to connect with me there on. Shoot an email, and yeah, I'll be here to help. Eugene, are you back? Or the colleague?
Yes, I'm back.
Good.
Asante sana Cephas for taking us through the wonderful session. I don't know if there is any question before we lock anyone out. Any question? Perhaps you could raise your hand or type in the chat box. Yeah, in the meantime, I want to thank everyone for taking the time, for taking a break during your work schedules and to attend to this session. We do not take it for granted, and we also want to thank everyone who made it for today. And we hope that you are able to grasp some concepts in today's training. So before I lock anyone out, anyone who has something to say, a comment, a recommendation, or even a question? Yeah.
Uh, Eugene, was this session being recorded?
Yes, the session was being recorded, and also you can follow it on YouTube. I'll post
Okay.
I'll post the video link just in a short while. This is the video, just a minute. Being recorded, and also you can follow it on YouTube. I'll Yes, that's the link to the video. You can just follow up in case you missed a portion of it. Yeah, friends, just to wind up, this is Capable Limited, and also we also offer training, and also to bring it to attention that we were certified by the Ministry Department of Office of Data Protection to offer data related training, that is data protection related training. So in case you're interested to attend any of our session, please reach out to us at info@capable.com for more details. Yeah, also in regards for any corporate training, be it Excel, be it business related, audit, tax, we also offer training on those areas. Please reach out to us and we'll be able to assist you accordingly. So having no other remarks, I'll give it back to Kefas to say or to give us the parting shot, and then we will be able to solve the meeting.
Eugene, no part for me, but I just appreciate everyone who's come through. Hope the information helps, and yeah, we are here to help. So you can always feel free to reach out. Cheers. Back to you, Eugene.
Sawa sawa, asante sana. In case of anything, please reach out to info@capable.com and we'll be able to assist you accordingly. Yeah, without much ado, I would like to end the meeting here and see you next time, same place. Asante sana. Have a good afternoon.